Welcome to another legal talk right here on eRadio with Hahn and Hahn attorneys. As always, Jan with you, and today joined by Nirvana from Hahn and Hahn. But something has changed since we last spoke to Nirvana, and I almost didn't recognize the name this week when she sent me an email. I was like, oh, is this somebody new at the company? But it's actually Nirvana. She recently got married. So first of all, Nirvana, who's now Nirvana Nothnagel, which is Afrikaans surname, I think. Congratulations.
That's great. Thank you so much.
How does it feel?
We've been together for 8 years, so it doesn't feel that different.
Okay.
I think we're calling each other Mr. and Mrs. Nothnagel now, so
Yes.
it's quite nice.
Yes, okay, no, because I was so used to Nirvana Pillay, so it's something for me to get used to now. But congratulations, indeed, and that's fantastic. I'm very happy for you.
Thank you so much.
So today on Legal Talk, we're talking about transferring a house and just briefly explaining the process. I think we'll start off with this one. What document initiates the transfer process, Nirvana?
Right, yeah. So the document that will initiate the transfer process will be the offer to purchase. So from this document, we'll be able to ascertain the parties to the transaction, the estate agent, the commission payable, what the purchase price is, and how that purchase price is payable. So they will either pay a deposit, and then there'll be a cash component that will be payable later on, or it'll be a deposit and a bond financing, or it could just be a full cash transaction or a full bond transaction. The obtaining of the bond would be considered a suspensive condition, and this is a condition upon which the offer to purchase relies upon to proceed further. Should these payments not be made on time, or should bond financing not be obtained in time, and the parties do not agree to an extension through an addendum to the offer to purchase, then the offer to purchase will become null and void.
Okay, and what are the first steps to be taken?
So the conveyancing secretary will need to contact the seller, the purchaser, and the estate agent and obtain documentation relevant for the transfer. These documents will include proof of residence and postal address, proof of banking details, your proof of SARS income tax number, a levy statement if it's a sectional title or where an HOA is involved, rate statement, bond statement if the property is subject to a bond, copy of identity documents, copy of the title deed, which the conveyancing secretary may obtain from a windy property search, should the seller not have a copy. And this search can be done on the seller's name and ID number on Windy. Further documents will be required, for instance, a trust or a company or a CC, for instance, the trust deed or the company registration documents, proof of VAT registration number, ID documents of trustees, directors, or members of a company or closed corporation. You'll also need to know whether there's an electric fence or gas installation involved in order to determine what certificates of compliance are to be obtained. The offer to purchase will also offer some insight to this. The seller may need to obtain all or some of these certificates, and these certificates would be the electric fence certificate, a gas compliance certificate, electrical certificate of compliance, beetle certification, which means that the property is free of wood-destroying beetles, or plumbing certificate. But the offer to purchase will generally stipulate what certificates are required.
Okay, what happens once the suspensive conditions are met?
So the conveyancing secretary will send a letter to the bank requesting cancellation figures. This instruction will then be relayed to the bond cancellation attorneys by the bank, who will then engage with the transferring attorney. So the transferring attorney deals with the transfer of the property. The bond cancellation attorneys deals with the cancellation of the bond. Should a bond be obtained by the purchaser, so bond financing, then the bond registration attorneys will contact the transferring attorneys and request guarantee requirements. This will either be broken down in respect of cancellation figures payable to the bank and the balance payable to the transferring attorney's office for the seller, or it may be one full amount if no bond is involved. Guarantees will then be issued by the bond registration attorneys and provided to the transferring attorneys. The conveyancing secretary will also need to apply for rates clearance figures and levy clearance figures if levies are applicable. Generally, the amount payable will be for a period of 3 months in advance, and this is for the payment by the seller prior to lodgement. So these clearance certificates have to be obtained prior to lodging the transaction. The transfer documents are to be drafted, and then the seller and purchaser are to sign these documents. Transfer documents are drafted on receipt of the information requested from the seller and the purchaser, together with a copy of the title deed, in order to carry over the title deed conditions, except conditions relating to mining and mineral rights which have fallen away, but may still be contained in all the title deeds. Pro forma accounts will be sent to the purchaser for payment. This will include transfer costs and transfer duty payable and or VAT payable by the purchaser, as far as transfer duty receipt or a certificate of exemption is required for lodgement. And you cannot lodge the transfer document or the transaction without having this certificate.
Okay, well, that's quite a process. What should the conveyancing secretary or conveyancer check before lodgement, Nirvana?
So most importantly, they need to check that the full purchase price is accounted for. So either the deposit or the full purchase price is held in an interest-bearing account by the transferring attorneys. That the interest that's generated on that amount will then be paid to the purchaser on registration, or that all the guarantees have been obtained. They also need to check that all clearance certificates and compliance certificates have been obtained, and all transfer documents are signed and in order, and that there's sufficient time left on the certificates in respect of expiry dates in order to avoid having certificates expire whilst in the deeds office. That all attorneys to the transaction are ready to proceed to lodgement. There are instances where this can be affected, where, for instance, the seller doesn't keep up its bond payments, and therefore new figures have to be obtained, the existing guarantees have to be cancelled, and new guarantees issued. So it's very important for the seller to maintain their bond payments if there is a bond subject to the property. Then all attorneys' offices will then arrange for simultaneous lodgement.
Okay, and our final question, what happens once the transaction has been lodged and thereafter?
So once the transaction has been lodged, it will go through the various examination stages at the deeds office. Should there be an issue with the transfer documents or the bond documents, then the deeds office will issue notes to the relevant attorneys. You'll be able to check this on your WinDeed system, for instance, because you get a barcode number, and then you can keep checking where in the process your transaction is. Once you receive those notes, you then rectify them, and then you'll have to arrange for re-lodgement simultaneously once again. If there are no notes issued, then the matter will eventually be registered. So it goes on to prep, and then you have to arrange with the relevant attorneys to proceed to registration. Once the registration takes place, then the transferring attorneys will let the bond registration attorneys know that the matter has been registered and that they need to pay out the guarantee. This is where there is a bond being registered. And then the transferring attorneys will then attend to a reconciliation for both the seller and the purchaser, and payments will be made to the relevant parties. If the transferring attorneys hold the full amount, they will release the investment and attend to a reconciliation and make payments to all relevant parties. In both cases where a bond is involved, the transferring attorneys will have to wait before attending to a reconciliation, as interest is payable on the bond cancellation figures. So this will then affect the payout to the transferring attorneys in respect of the money that needs to be paid to the seller. And then only upon receipt of the newly registered title deed will the firm be able to close its file. And to this end, the new owner will need to collect the new title deed, or arrangements will need to be made to get the new title deed to the new owner.
And that's how you transfer a house. Thank you, Nirvana. Thank goodness this is a podcast, so we can listen to all those steps again. It appears to be quite a process.
It is quite a process, but generally a transfer process takes about 2 to 3 months in total, from receiving the offer to purchase to registration stage.
Nirvana, thank you so much. That was Nirvana Nothnagel, Associate Attorney at Hahn and Hahn, for this week's Legal Talk.
Thank you so much, Gian, for having me.
Are you or your business in trouble and struggling to find a solution? Call Hahn and Hahn Attorneys as we assist clients in finding solutions. We specialize in consumer and food law, commercial and construction law, forensic investigations, and administrative law. Visit hahnlaw.co.za. That's HAHN. We assist clients nationwide. Hahn and Hahn Attorneys, because we care. Don't miss Legal Talk with Hahn and Hahn Attorneys, Wednesday mornings at 10 on eRadio.